Your Honor, I've
case.
represented her through all this. I don't remember Judge Gangloff looking at any videos.
One, this is your exhibit, right? I'll turn it back to you, counsel.
Your Honor, you required staff beforehand to be able to get the electronics working.
Mm-hmm.
I guess we're going to need that same assistance.
All right, so are you seeking to play something at this point?
Yes, I would ask that you do.
All right, is this just so the record's clear, this is a flash drive of something? Who wants to predicate or tell me what this is that's being played?
Judge, I volunteered this flash drive to refute the claim that there was an assault on this day.
Okay.
I have no objection to them playing it in their case. We were going to play it in ours anyway.
Okay, fair enough. So we'll mark it as D. So I don't know where the volume is, but whatever's a comfortable level.
There was a long oral argument, Judge. But
All right. Well, let's let it. It'll speak for itself, I'm sure. I can see the video from here. It shows the back. It looks like the back of a house, which looks to be a one-story or possibly a split-level ranch with a, looks like a back porch with a either French door or sliding door in the middle of the back of the structure I'm looking at, with some cars parked on the left side of the video. Looks like someone may be sitting on the back porch on the steps from where I'm seeing. And I don't know, counsel, you just want to play it through? Is that what you want to do? All right, well, I'm going to step down so I can get closer to see what I'm seeing and hear what I'm hearing.
Judge,
What's going on?
the attorney can't whisper to his witness.
Oh, I didn't see that, but, all right. I don't know what's going on there, but you can ask questions, counsel, go ahead.
Your Honor, you've never been accused of whispering an answer or something like that.
All right, well, I didn't see it, so I'm just asking you to
And
continue.
I'm just telling you that did not happen.
All right, fair enough. Go
I
ahead.
said, do you need more time and a rest from this?
Fair enough.
Did it look red to you?
There was a red mark where his thumb was.
You seemed to hesitate before
Well, there
answering.
was. But I didn't take a photo of it. I don't think to do that.
Now, did you hear the sirens from the police vehicles immediately before he tried to move you into the house?
I didn't call the police.
It's just a yes or no. Did you hear the sirens in the video that I presented?
No, I didn't hear them.
You didn't hear the sirens?
Nope.
Didn't the defendant clearly stay on there? The police are coming, let's go inside.
I think he no, I don't think that's what he said.
So your
Is that what
testimony
he said?
Your testimony is that he did not say that on the video.
I didn't call the police, so I don't know why the police would be coming.
I'm not asking you about why the police are coming. Isn't it a fact that on the video, the defendant is clearly saying, let's go inside, the police are coming?
To my knowledge, he was telling me to go the fuck inside, just to go inside. I did not hear anything about police, or hear police sirens.
Okay. And after the sirens died down, then he
Your
didn't
Honor, I
touch
ask that that be stricken. Nobody said anything about these sirens.
Pardon me?
I believe the court heard the sirens.
I heard sirens. I don't know if you heard them on the.
No, I didn't.
I didn't.
You can hear sirens. I can't say they're police sirens, but there's some sort of siren noise being made on that video in what I observed. So, at any rate, I characterize them as a police or some other emergency response may take it a little bit beyond, but I did hear some sirens in the background. But that being said, I'm not going to strike it, counsel. You can continue. It establishes that there are clear problems with this relationship, clear problems with this marriage, but those problems, again, are for a separate docket because I don't find that the proofs establish a basis for a final restraining order. So good luck to both of you. I know this is a difficult time for both of you. I'm not trying to minimize that there are problems here because clearly there are. But like I said, there are different dockets and different proof elements that are required in these cases, and the proofs don't arise to the level of issuing a final restraining order. So good luck to you folks. I wish you the best going forward. Thank you.
So two documents that you marked, I can have them back.
No, they have to be maintained in the court file as evidence.
Can we make a copy of
The decision that I have to make whether to issue a final domestic violence restraining order involves a two-step analysis. First, I have to determine whether the defendant committed one of the predicate acts set forth under the statute against a spouse or other persons protected by the act. Second, I have to determine whether in light of all the circumstances, including the nature of the act, any past history of domestic violence and the entire relationship between the parties, domestic violence restraining order is necessary to protect the plaintiff from immediate danger or further acts of domestic violence. Jurisdiction in this matter is proper. The alleged acts took place in Gloucester County. Plaintiff is a protected person under the act because she's over the age of 18 and she's married to the defendant. The standard of proof that has to be applied here is preponderance of the evidence, which is a civil standard of proof. The predicate acts, as alleged, are harassment and stalking. Harassment is defined as a person commits a petty disorderly person's offense if, with the purpose to harass another, he makes or causes to be made a communication or communications anonymously or at extremely inconvenient hours or in offensively coarse language or in any other manner likely to cause annoyance or alarm. Testimony of the plaintiff is that he said that the job looks good on you, Lori. It was not an anonymous statement. It was not in an inconvenient place or time. It's not crude or foul language.
Can I also just say, though, that you put in place a no contact rule
And
on
ma'am,
the
you have
18th?
absolutely every right to file a civil motion if you feel that that rule's been violated, but that's a different issue than what's before me today.
And you don't feel that him walking by with my back to him, that I would have never even known he was in that
Ma'am?
store at
Ma'am,
all?
this is a domestic violence court. If there's been a violation of a civil order, you have every right to file an application to
Right, but
enforce
I'm
that.
just saying, for that, for the stalking, for the harassment, I wouldn't even known he was in that store.
Ma'am, I understand your point, but you have, that is not harassment as defined by our statute. Stalking is defined as repeatedly maintaining a visual or physical proximity to a person directly or indirectly or through third parties by any action, method, device, means, following, monitoring, observing, surveilling, threatening. He has provided the court with evidence that he had a legitimate reason to be in that target. His mother had a prescription there. He filled the prescription was filled. He went in to pick up the prescription. There's no evidence before this court that he was there for any other reason. Perhaps he said something to you, ma'am, that you don't want any contact with him, and I understand that. But that's not stalking as defined by the domestic violence statute.
How about where her prescriptions normally were? Were they intentionally done at that store?
Ma'am, I have no proof that why they were there. There's no proof here whatsoever that he called in the prescription, that he had anything to do with where it was filled. And it appears as if it was filled and he was asked to pick it up. He has provided proof that he did pick it up and that it was filled in your store. So ma'am, you have not been able to prove a predicate act. I cannot enter a final restraining order. If either of you feel that there's been a violation of a civil stay-away order, both of you are entitled to file an application under that docket